Hello, and welcome to Picking Up the Pieces, an educational web series brought to you by Oliver Law LLC, a Colorado based family law firm dedicated to providing legal services to low and moderate income clients. My name is Justin Oliver, and I am the owner and founding partner of Oliver Law. And in today's piece, I'll be giving a broad overview of some of the initial steps and considerations that parties must contend with when initially filing for a divorce in the state of Colorado. Before we begin, I'd like to point out that the information contained in today's series is not intended to create an attorney-client relationship, and viewers should not act upon the information provided without first seeking professional legal counsel. There are two documents that are filed in the initial stages of every divorce proceeding in the state of Colorado. The first is the case information sheet, which contains basic information about the parties. It's generally the contact information. The second document is the petition, and the petition is a very important document to divorce proceedings, and it contains the basic information about the particular case at hand. And the reason it's important is because courts review these to identify any legal issues that may potentially arise throughout the divorce case. Now, there are other documents that may be required to be filed at in the initial stages. It really depends on the particular case and the facts and circumstances surrounding that case. And the classic example is if you have parties that are not filing jointly, if there's only one party filling out the petition and filing it with the court, then that party is required to also fill out a summons so they can have that served upon the opposing party. Residency is an important consideration in Colorado divorce proceedings, and it's important for a number of reasons. The first of which is because divorce cases need to be filed in the county where one of the two parties reside. Another important reason to understand residency is because at least one of the two parties to a divorce proceeding must reside in Colorado for at least 91 days before the initial paperwork can be filed. Now, if there are children involved in your divorce proceeding, meaning that there are children of the marriage or children that have been adopted into the marriage, it's important to note that those children must reside in Colorado for a minimum of 182 consecutive days prior to the filing. Otherwise, issues related to the children, including parenting time, decision-making responsibilities, and child support, cannot be addressed in the actual divorce proceeding. It's also important to note that once a divorce action has been commenced, once it's begun, there is a mandatory 91-day waiting period before a Colorado court can actually enter a decree and finalize the divorce. Another very important consideration in Colorado divorce is the temporary injunction. And temporary injunctions are something that are often overlooked by people who are unfamiliar with the divorce process, but they are very important and worth taking note of because at the very beginning of the divorce process, an automatic temporary injunction goes into place. So these injunctions are automatically put into place at the very beginning of the divorce process, and they remain in effect until either a final divorce decree or a subsequent court order is put into place. Now, these temporary injunctions cover a lot of topics, but generally they prohibit parties from acting against the interest of the other party. For example, it places restrictions on the transfer of marital property, the discontinuation or modification of insurance plans. It prohibits parties from taking marital children out of the state during the court proceeding without court order or consent. So there's a lot of legal ramifications to these injunctions, so it's very important that you understand how they affect you and your rights. Once the initial paperwork has been filed in a Colorado divorce proceeding, the all-important step of personal service arises. And there are a number of ways that parties can fulfill the personal service requirement, and the three most popular ways are listed there on your screen. There's filing of a co-petition or filing jointly, and that's where both parties complete and sign the same petition and file a single petition with the court. The second way is through service of petition and summons. And how that works is the filing party or the petitioner has a copy of the petition and the summons served upon the non-filing party or the respondent. And this service has to occur by a disinterested party who is 18 years or older. Now, the third common way that the personal service requirement can be fulfilled is through waiver and acceptance. And this is where the respondent or non-filing party fills out a form that says that they accept, they waive and they accept service as it is. You don't actually have to have them personally served by a disinterested 18-year-old or older person. Now, it's important to remember that, as a general rule, the other party must have the same documents that you have. So, anything that the court gives you as far as scheduling or upcoming deadlines, it's important that you make sure that the opposing party or your soon-to-be ex-spouse gets a copy of that paperwork. Also important is that once you have completed service, it is important that you provide the court with proof of service, some sort of signed affidavit, or again, the waiver and acceptance from the respondent. So once the initial paperwork has been filed, service has been completed, and proof of service has been provided to the court, you may be asking yourself, what comes next? Well, in any given divorce proceeding, there are a number of documents that may or may not need to be completed at this point in the divorce process. I've listed a number of the documents that are typically completed during this portion of the divorce process. They're on the screen. But at this point, I will pass on going into any in-depth discussion about any single document, as they are very nuanced, can become very complicated. It really depends on the facts and circumstances of a particular case. Now, what I would like to go ahead and point out are two important issues, one of which is that if children are involved, then a child support worksheet will need to be completed, and that's something that is not listed there on your screen. A second thing worth pointing out is that several of these documents do have a notary requirement, which means that they must be signed by a notary of the public before they can be filed with the court. Now, it's very important that any of these documents that need to be completed for your specific case, or for any specific case, they need to be completed as thoroughly and as accurately as possible. And that's so you can avoid future complications with your case and the possibility that you may damage your credibility with the court and ultimately hurt your position in your divorce proceeding. The last topic that I'd like to discuss in today's Picking Up the Pieces segment is the initial status conference. Now, it is the petitioners, and the petitioner is the person who filed for the divorce. It's the petitioner's responsibility to schedule the initial status conference and provide notice of the conference to the other parties in the case. Now, each judicial district in Colorado has their own established procedures for setting the initial status conference, so it's important to learn your local rules before filing. Now, the initial status conference should take place as soon as practicable, but no later than 42 days from the filing of the divorce petition. At the initial status conference, the parties can discuss the status of the case, exchange forms that are relevant to the case, and formulate a plan for moving forward with the divorce action. Now, these initial status conferences are generally informal in nature, but the parties do need to be prepared to discuss and formulate a plan, what needs to be done, determine a timeline of completion of the case, and generally these things are best facilitated if the parties confer ahead of time on any unresolved case-related issues. And this concludes this section of Oliver Law's Picking Up the Pieces. If you have specific questions about your Colorado family law case, I do encourage you to contact Oliver Law LLC. And don't forget to visit our website at oliverlawcolorado.com and like our Facebook page at facebook.com/Oliver Law Colorado. Until next time, my friends, this is Justin Oliver signing off for Oliver Law and the Picking Up the Pieces educational web series.